Okay, good afternoon. Let's get going. Welcome to this lunchtimes session. And today we're going to look at the Procurement Act. This is only a whistle-stop introductory tour to it. But hopefully it'll give you some idea of what to expect when it gets implemented. So I'm Tim Rivet, and I'm going to be running through this session with you. We are recording it, and we'll share the recording for you to review later and share with colleagues that couldn't make it live. And I'll share the slide deck as well in the next couple of days. And we'll have an attempt at Q&A at the end. I am by no means an expert in all of this. I've just been through and picked out a few things that I think will be particularly of interest to you as members and people interested in real-time and public transport tech. So we'll have a look at implementation, run through some of the procedures that are in there, some of the new things and some of the changed things, look at the administrative and performance management aspects for contracts that are in there, because there's some significant differences and implications there. Look at the transparency side of things, publishing of notices and things like that. And as I say, we'll attempt a Q&A. Before I go any further, though, I do need to say this is not legal advice. There are people that earn a living as lawyers for major firms providing professional procurement advice and legal advice around the procurement rules and things like that. This is just things that I think are likely to be of interest to you. So please don't go away and take this as legal gospel and try and take people to court over it and things like that. I am not a lawyer. So why do we have the Procurement Act 2023? So in a post-Brexit environment, a lot of the procurement rules and procedures that we've been following for the last couple of decades have been based around European legislation. They therefore need to be replaced, particularly because European procurement is also changing, and so otherwise we would have been left with some rules and processes that were out of kilter with what our neighbours were doing and also the wider world. We also have quite a lot of historical UK procurement laws around, and in the classic burning of legislation, it was decided to get rid of a lot of that and try and simplify things, try and reduce the number of opportunities for expensive legal cases and things like that, and make it simpler for everybody. And we do need, particularly from a public sector perspective, to have a current set of procurement laws and rules, because as part of the World Trade Organization, we need to have these things in place, particularly, as I say, for government procurement. The Procurement Act 23 covers England, Wales and Northern Ireland. If you have interests in Scotland, then procurement is devolved, and so the Scottish Parliament is introducing new and updated rules, which inevitably are ever so slightly subtly different. So what I'm going to go through is subject in England, Wales and Northern Ireland. It covers central government departments and its arm's length organisations and agencies, the wider public sector, so local authorities, utility companies get a specific mention, so things like water and gas and organisations like that, they have to do procurement following public sector rules, and transport sectors. So the LTAs that are now combined authorities, and the publicly owned ports and airports that are around have to follow these rules as well. Of course, if you're in the private sector, you don't need to follow these. You can set your own procurement rules and things like that, but generally a lot of the ways of doing procurement, particularly in larger private sector organisations, have some heed to the sort of processes that are laid out here, largely because suppliers are used to following them. So when we came up with the concept of needing to cover and do some introductory work on the Procurement Act, we set it to the end of September because that would have then given people a month before it came into force. However, since then, the implementation date has been extended, so it now doesn't take effect until 24th of February next year. Gives everybody a few more months to get used to it, and it also allows the new government to publish its procurement and spending rules, which will inevitably have an effect on how people are going to procure, and a procurement strategy for government and things like that. So there's a few more months before it kicks in, but given some of the changes that are in there, that's probably something that a lot of authorities in particular are quite grateful for. If you've got procurements underway now, or contracts, they will still follow the existing 2015 rules, and any new procurements that you start will also follow those rules, but the general advice would be you should take heed of what's coming and adopt as many of the new things as possible, but legally it's the 2015 rules that will still apply. If you've got a framework contract that you use or you're on, they will continue even for call-offs under that after February. They will continue to be governed by the old procurement rules and the rules that framework was procured under, and it's only once that framework closes that any new rules kick in. So if you were to let a framework fairly soon, a good example of that would be some of the Crown Commercial Services frameworks, G-Cloud, which a number of you will use or be on, I'm sure. They're about to release a new version of that. That will be open for a further 2 years. So call-offs under that will still be governed by the old rules for a couple of years. And potentially longer if you've got extensions to contracts and things like that. So this isn't just a suddenly flip the switch and the new rules apply across the board. It's going to be a bit of a confusing time in the event of challenges and problems with contracts for a few years whilst everything swaps over. So the Act sets out a number of basic procurement principles. Fundamentally, it's all about transparency, and the core principles don't change. You would expect, as is the case currently, the procurements are going to deliver value for money, particularly for public sector. There is a new principle around it maximising public benefit. So think about things like the social value requirements that have been coming in over the last few years, where typically 5 or 10% of the award criteria for a contract's been requiring people to do social value things, environmental things, that sort of thing. It's now enshrined in the principles, and you're going to have to allocate at least 10% to social value. There is a requirement to share information to make sure suppliers and the public who might want to understand what's going on, to understand how an authority's procurement policies and decisions are made. Publishing processes and procedures, rules around at what point you need multiple quotes and what sort of tenders at what levels and things like that. There is a new principle around acting and being seen to act with integrity, and an interesting one linked to that about equal treatment and non-discrimination. So particularly that is in areas where you might be dealing with small, medium enterprises and voluntary and VCSE type organisations, because one of the objectives of this is to try and get more public sector contracts being awarded to smaller organisations and voluntary organisations to help growth in that sector. So some useful procurement principles. There are fundamentally now only 2 procedures that are available. There is the open procedure, so this is the thing that you might be used to. It's pretty much largely the same as the Public Contracts Regs 2015, which govern things. So single stage procedure, you go out, so you want to buy something, you go out with a specification, and people can then return tenders, quotes, whatever level is needed. So that should be fairly familiar to people. And the other procedure is really quite wide-ranging, really quite open, and it's probably not fair to call it just a procedure because a whole range of things fall under it, and that's the competitive flexible procedure. So previously you had a number of options around frameworks and negotiated procurements and things like that, and they were listed separately. All of these sort of things will come under competitive flexible procedure. You can create multi-stage procedures. There's very little defined here, so individual organisations can define approaches that they want to follow and think are appropriate. So we will still see selection questionnaires and pre-selection things going on, and then an ITT to get shortlisting and things like that. Or you could do things a bit differently. You could do a bit of sort of fixed procedure to get to a short list of a couple of organisations, and then go into negotiations and things like that, and follow the sort of things that you might have done under a negotiated procedure. But procurement teams understand and know and are used to following, single stage and two-stage procedures. So my gut is that, at least for the time being, going to be pretty much the same sort of procedures and processes that we're going to see going forward. Under competitive flexible procedure, there is a new concept of dynamic markets. So previously there was a specific procedure for dynamic purchasing systems. So, this isn't like a framework where you open up, you get people on board, and then you are closed until the end of the framework. The dynamic purchasing systems and now dynamic markets are similar to frameworks. You allow people on that meet a minimum specification, but you have to open it up on a regular basis or on a constant basis to new suppliers to come in. They might have only just found out about it, or they might be a new startup or something like that. Dynamic purchasing systems were restricted to quite specific areas, and you had to be quite specific about what you were going to buy, or either goods or services. But dynamic markets are much more open. They are much more flexible, and I can see some interesting challenges around that, because with flexibility comes opportunity for people to do things that weren't intended. One of the protections around that is that when you go out for a tender within that dynamic market, that needs to be published to everybody in the world, not just those on the marketplace, so people can see what's being procured, as well as the contract awards and things like that. So that would give somebody the opportunity to try and get onto the marketplace, to be involved in a particular procurement, mini competition type arrangement within it. So the aim being to get more people on it and a bit more competition. Frameworks at the moment can only run for 4 years. That's been quite restrictive and challenging for some people. They can now run for 8 years, and even a closed, in inverted commas, framework is going to need to be opened up on a regular basis at least twice in that 8 years, to allow new people to get on, and tweaks to contract terms and things to be made. You can, under frameworks, do direct awards, and there's a bit more flexibility with that. So at the moment, with a direct award, the contract terms that the framework had to be applied completely. There was no opportunity for variation, but you're now going to be able to adjust some of the more minor terms if that is more suitable, as long as the core terms are being followed. So, for example, at the moment, if you went out and had a framework for real-time displays, and that specified that it was a 3-line LED in a black case, you couldn't change it. If corporately there was a decision that you were going to use blue as your corporate colours rather than black, you'd have to close the framework and reopen it. Whereas now, as long as the core terms are followed, you could go, actually, we want blue cases rather than black, for direct awards. For mini competitions, though, as I read it, you have to still apply all terms, but mini competitions, we all know, you put something out, much shorter timescales than needing to go for an open procurement. That doesn't appear to be changing. But what you do need to do is publish more information on call-offs. So like direct markets, you have to publish that notice to the world, and then publish what's been awarded as well. So more transparency in work here, and that whole transparency thing keeps following through in a lot of the changes. In terms of timescales for procurement, there's a new approach where for light touch procurements, there is no minimum time scale. So light touch is a new concept, and you would use that, for example, where you might have social care budgets and things like that, and you need to procure, a carer for somebody. You can open that up and close it within a day if that's what's needed, but you can't do it for lots of procurements. There's some definitions around light touch. State of urgency, so the world's ending. This is in response to some of the challenges that the pandemic raised. So in a state of urgency, and there's definitions of that, you only need to keep that open for 10 days. So not very long, but at least it overcomes some of the need for emergency unprocured goods and services. Standard procurement timescales, 25 days. But if you're not doing it all electronically, then it's got to be 30 days to allow for post and things like that. So people have been keeping things open, for 25 days for a while now, so that shouldn't change very much. In a dynamic market, you can keep things open for 10 days. So again, much shorter timescales than people are used to. In reality, you've been able to do that with frameworks for a while, but that's not giving people very long, particularly if it's not, you're just buying something more complicated than pencils or paper clips. You do need to think about actually what's reasonable for suppliers to be given to provide you with a decent response. With an eye to the environment and carbon footprints and things like that, and fewer people eating animal products. Meat is becoming MAT. No, I'm kidding. But meat is becoming MAT. So we are used to most economically advantageous tender. The E is being removed, so it becomes most advantageous tender. That's trying to help improve quality aspects, and particularly in light of the need for social objectives and environmental objectives to be included. So economic goes, but it's still most advantageous tender, and that is a reflection that you can include more things now in the assessment of tenders, and we'll come on to some of those issues in a bit because they're quite significant, particularly for suppliers. So you've gone out, you've got bids back, you then need to evaluate, but actually before you even go out now, in the procurement notices, you need to be predefining much more detail than you do now the evaluation and award criterias. So at the moment you need to say as a minimum, it's going to be 40% price, 60% quality. But going forward now, you need to be publishing up front much more about your evaluation criteria and how you're going to award it. And as part of evaluation, it introduces assessment summaries. You're probably quite used to, once you've done evaluation, writing out to suppliers to, say, sorry, you haven't won, you scored this, the winner scored X. These are the relative comparisons. The new Act requires in some ways more detail to be provided. It's a bit more specific in what you do need to provide. So even if you're the winner, you will get to see more than just, you scored X and therefore you've won. So helping winning suppliers who at the moment are quite in the dark. And there's some examples in the guidance and things like that of the sort of information that's being expected as to why they think you were the best supplier. Now, at the moment, when you provide feedback, it's normal to directly compare the successful and the unsuccessful suppliers' tender responses with an assessment summary. It's got to provide a copy of the information provided to the successful supplier. So, why did they win? Of course, if there's stuff that's confidential, then that needs to be redacted. But I can see some interesting issues potentially where you go, we really like this supplier and they've won because of this bit of functionality that actually other people might not have. An authority might not realize that that's quite commercially confidential to a winning supplier. So I can see some interesting conversations around that. So got to provide the information that was provided to the successful supplier and also how the unsuccessful supplier's response was scored and why. You don't need to do that direct comparison, but an unsuccessful supplier will have those two bits of information and be able to work it out themselves. So a little bit more work for suppliers if you're trying to work out why you didn't win and what you should be doing differently later, but it probably overall provides you with a bit more information. This is out of order. Actually, this would have been better a bit earlier. So there is a new central procurement platform being put in place. People should be able to have access to it ahead of the February go live. But basically, this is a find your tender on speed. Much bigger, does more things, and it is the place where authorities are expected to be putting their notices and all the supplier information. And in theory, it's where you as a supplier should be able to go on, register, answer all of the standard questions about whether you've been good or bad, whether you've got any convictions and things like that. And you only need to do it once, and everybody should then be using that to access. You will also, as a supplier, have a unique new public procurement organisation number. So, when you're dealing with authorities, you can say, this is my organisation number, and then they can go and pull your records and see everything. So you only need to keep that updated once. None of the challenges that suppliers on multiple procurement portals have at the moment to keep, insurance documents up to date and keep things, up to date in multiple places. But authorities will be expected to use the platform to publish all of their notices about future procurements, ongoing tenders, and also contract performance, and we'll talk about that in a minute. And the expectation is that it will be used for selection questionnaire stage. So, as I say, you only need to answer those questions once for any procurement you're ever going to need to do. Unfortunately, for those of us that get involved in procurements all over the place, there will still be a plethora of procurement portals, because once selection stage has passed, or you're doing a single stage procurement, you're still going to need to respond to the individual tenders on those procurement platforms. So unfortunately, it still causes challenges at that point, but even if it's a single stage, they should be using the central platform to get all of your standard information. A key thing that the central platform will help manage is supplier performance information. Any contract that has a value over its life of more than 5 million is going to be expected to define and set at least 3 key performance indicators for how supplier performance is going to be measured, and those KPIs and the performance against those is going to be published at least annually. And authorities are going to be expected to do an assessment of performance against that KPI in single word type answers, a bit like Ofsted have been doing. So, inadequate to good type assessments. Now, these KPIs I can see being the subject of lots of debate and discussion. When there are pre-market engagements, I would suggest that these are the sort of things that, as a supplier, you might want to be influencing. As an authority, you might want to be finding out what the market will accept as KPIs. Because, for example, if you're buying a real-time system, suppliers might be happy to publish things like response time to faults on displays, how do they perform against that, or system uptime and availability, those sort of stats. But an authority, and bear in mind that these will be available publicly, might be interested in things that are perhaps more challenging, like how does the supplier manage journey matching, so percentage of journey matching, or how accurate are the predictions that are being provided, things that as a supplier you might be less comfortable having published, but authorities doing the procurements might be more interested in. So there's going to need to be some debate and discussion about what those should be. Perhaps as something that we can talk about in the in Q&A. Actually, is this something that ARTIG might want to come up with a set of suggested KPIs that, as an industry involving everybody, we can come to some consensus and agreement on as suggestions. A key thing with these KPIs is that if a supplier is performing badly on contracts and the problems aren't rectified, then there is a risk of exclusion from that contract, so you can be thrown off that contract, but also it becomes a discretionary exclusion opportunity for future contracts. So you have the normal mandatory exclusions for where an organisation has been doing things illegally and they've got convictions and things like that. You've got discretionary runs where you might have done something, you've put in place an action plan and it's resolved. So poor performance will become a discretionary exclusion, but you can quite easily see how authorities might use this to help with shortlisting and go, actually, these we want to actually use to exclude people. So not only any underperformance or a breach will be available for everybody to see. So yeah, it's worth a lot of thought going into what these key performance indicators are to come up with things that are going to be useful for everybody and reasonable as well. Other issues with supplier behaviour, we've touched on mandatory and discretionary. If you've come to a settlement agreement with an organisation for poor performance or termination of contract for whatever reason it is, then they will have to be identified and can be used for exclusion from future procurements, not just for the original authority where that agreement was put in place. Something of note, particularly for larger organisations with long and complex supply chains, supply chain compliance for the mandatory and discretionary exclusions come into play. So you're going to need to understand your supply chain much better. Have any of them committed any of the mandatory exclusion reasons? It brings into play bribery and modern slavery and some of those other things that are discretionary at the moment, and you're going to be expected to keep an eye and monitor their compliance with these things on an ongoing basis. So quite a lot more work around the supply chain performance for suppliers, and it's also going to be possible for authorities to require subcontractors to have binding contracts in place around behaviours and performance as well. Yeah, a lot of work to do, I think, to make sure that supply chains are being managed more effectively and efficiently. We've touched a bit on people being barred from future contracts and things like that. There is going to be a new debarment list. If a supplier is on there because they've got some of the mandatory reasons, as well as some of the discretionary ones, if they've been excluded from contracts for poor performance and things like that, an authority must pass that information to the central authority for investigation as to whether that particular supplier should be on the national debarment list. And if you're on that list for a mandatory reason, then exclusion is going to be mandatory and binding on all authorities. So that's pretty much a end of business situation. There is opportunity to appeal but I can see that ending up being quite expensive and needing lots of legal advice and things like that. If you're on the list because of discretionary reasons, then that's again discretionary for the supplier, for the authority, but you really want to be avoiding being in that position, which is why it's going to be very important to make sure that you understand what's going on, not just in your own organisation, but in your supply chain as well. So assuming you've actually not on a debarment list and you've tendered, you've had evaluation carried out, then you're not going to get a standstill letter anymore. You're going to get contract award notices and assessment summaries. We've talked about the assessment summaries. Contract notices, though, are a bit different. The release of the contract award will now trigger what used to be called the standstill period. Once the contract award notices are published, there is only 8 working days to trigger a challenge. Now, whilst that's less number of days, it is now specific that it's working days. One of the things that has always caused lots of debate and discussion is when does the previous 10 days take effect. Previously it was 10 calendar days, so actually not a lot of time if it done over Christmas or holiday periods and things like that, whereas 8 working days is a bit more useful. It's a lot clearer, but making a challenge will automatically suspend the contract, and unsuspension, the processes are not very well, they're not defined, because those are the things that are expected to be determined in court. So a challenge could therefore quite quickly become expensive with lawyers and things like that, and I can see being subject to lots of case law to build up over the next few years. But the key thing is, until you've actually issued the contract award notice, the standstill, the challenge period doesn't start. So subtly different point at which that kicks in. So you need to publish those award notices and the assessment summaries, but that's not all. There's an awful lot more work for authorities to do around noticing and transparency. So I can see a lot more paperwork for people involved in procurements, not just procurement teams. There's a whole set of new requirements for publishing notices during the whole procurement life cycle. If an authority considers that it's going to pay more than £100 million under relevant contracts in a given year, so pretty much any reasonable size authority, certainly when you start talking about district councils and things like that, they're going to be covered by that. They need to publish a pipeline notice of their procurements for the financial year within 56 days of the start of the financial year, where any contract estimated to have a value over its life of more than £2 million. So quite a number of the sort of contracts that deal with real-time information and passenger information will be covered on that over if you look at it over the life of the contract. Yeah, So a bit more visibility if you're a supplier, more work if you're an authority. You've still got planned procurement notices, what used to be called PINs. You've then got preliminary market engagement notices, which you have to publish, is my reading of it, even if you then go straight from that to publishing the procurement on the same day. But you still need to do that. I might be wrong there, but that you've got to publish nationally the market preliminary engagements. You've got notices on the direct award of contracts, and a biggie is when there's a change to the contract. There's a wide number of reasons that when you do that, you need to then publish that change notice. So yeah, quite a lot of the time at the moment, you might not see a change notice to a contract. You're going to see an awful lot more of those in future, and you also need to publish termination notices for contracts. So even if that termination is not for poor performance or something like that, so at the end of a contract, you need to publish the fact that that contract has ended. Just to round things off, there's a few new procurement options available. Supplier behaviour and performance is probably the biggest thing, particularly if you're a supplier, to take away from this. Unfortunately, if you're an authority, it looks like there's going to be quite a lot more paperwork and administration to do, but the objective is to improve transparency of what's going on, who's got what contracts, when they end, and what the value is, and that sort of thing. A takeaway for suppliers is to make sure you get registered as soon as you can on the central platform, because that will become really quite important. There's a lot more information available on all sorts of sites. Any legal company that gets involved in procurement will almost certainly have anything. The government and Crown Commercial Services sites have got a lot of information. There's a lot of training available and things like that. This has just been a whistle-stop tour, picking out a few things that I thought would be particularly useful to highlight. It does not cover everything, as I said at the beginning. So, what questions have people got around this? No? Okay. I'm sure if you're an authority, you've got a procurement team who's been getting up to speed on this and be able to help. As I say, there's lots of other stuff out there on the web, training courses and things like that. So yeah, without any questions, I'll go on to the adverts. We continue to run events around the accessible information regulations and grant. So if you want to find out about that, bob onto one of those. We've got a face-to-face event in Birmingham at the end of October on practical bus priority, Q&A, self-help stuff, and what suppliers are doing in future. And on Halloween, we've got a session on ghost buses. Why do buses not turn up? Why do they turn up when you're not expecting them? All of that sort of stuff. We've got those coming up, and hopefully see you on one of those soon. And if you don't know how to get in contact with Artig, then that's how you can. So thank you very much for your time this afternoon. I hope you found it useful. Get in contact if you've got a question you didn't want to ask in front of other people. Thank you for your time. Thank you for watching this Artig webinar. To find out more about Artig and our work, then please visit our website at rtig.org.uk. Thank you.